Union territories. The term is self-explanatory. It means a territory of the Union. Easy? That's how this video is going to be. My name is Dr. Harman UTs and I am Assistant Professor, University Institute of Legal Studies, Punjab University, Chandigarh. At the end of this video, first of all, understand the concept of a union territory and how it is different from the states in India. Secondly, you will be able to understand the administrative setup as well as the legislative setup of such union territories, and then we will be discussing the special provisions pertaining to the union territory of Puducherry, and finally we will be discussing the constitution and powers of the various high courts which are established for the various union territories. Part 8 of the Constitution earlier dealt with Part C states. These were special states which were kept distinct and separate from the other states. The States Reorganization Commission, which submitted its report in 1955, recommended that the Part C states be converted into union territories. It was after the States Reorganization Act, which was passed in 1956, that the Part C states ceased to exist. Some of them attained statehood, while on the other hand, some of them became union territories. One of the Part C states, which was Ajmer, was merged in the state of Rajasthan. Another Part C state, which was Bhopal, was merged in the state of Madhya Pradesh. The earlier Part C states, which were Himachal Pradesh, Manipur, Tripura, Mizoram, Goa, all attained statehood. At present, there are 7 union territories, which are number 1, Lakshadweep, number 2, Andaman and Nicobar Islands, number 3, National Capital Territory of Delhi, number 4, Chandigarh, number 5, Daman and Diu, number 6, Dadra and Nagar Haveli, and number 7, Puducherry. Now we will be discussing the administration of union territories. Article 239 of the Constitution contains a special provision which provides for the administration of union territories. Under Article 239, it is the President who administers these union territories. Now, union territories, as we all understand, are territories which are administered by the Union. It does not mean that they are under the control of the central government. They retain their separate and distinct character. In addition to the President exercising powers as the administrator of a union territory, he may appoint another person as the administrator of the union territory, thus delegating his powers. Now, another provision in Article 239 provides that the governor of a neighboring state can be appointed by the President as an administrator of a particular union territory. Now, in this particular provision, any particular governor of a state can be appointed by the President as an administrator for a union territory, which means that he has to act independently of his Council of Ministers when acting as the administrator of a union territory. A union territory is a separate and distinct unit which is different from the states in India. What makes it special is that it has a certain historical, cultural or political significance. That is the reason why the Constitution of India provides certain special provisions with respect to union territories. Now, these Specific reasons why these union territories have a significance include, for example, Puducherry, which was earlier a French territory, and Chandigarh, which is the capital of Punjab and Haryana, and hence the central government and the union wants to retain control over the same. And further, the union territories of Lakshadweep and Andaman and Nicobar Islands, because of their distance from the Indian mainland, the union government considers it necessary to administer it themselves. It is noteworthy that it is only in case of Delhi and Puducherry that the constitution has envisaged a democratic setup. With respect to the other union territories, they have no legislatures. Which brings us to the next part of this video, which is the legislature of these union territories, which are special units under the Constitution of India. Now, the Parliament is vested with the power to legislate for the union territories under any of the lists. First of all, Article 246, Clause 4 provides that it is the Parliament which has the power to legislate for the union territories. In addition to that, under its residuary powers, under Article 248 as well as List 1 Entry 97, the Parliament has power to legislate over these union territories. Hence, the power of the Parliament is plenary in nature and cannot be fettered. Therefore, union territories are the territories which are directly administered by the centre, by the union government. Therefore, the Parliament has the power to legislate for these union territories. However, it is to be noted that Parliament is pressed for time when it has to be making laws for other parts of the country as well. Therefore, there are certain provisions, special provisions, which provide for the Parliament to delegate its powers further. By various acts of the Parliament, the power to legislate for the union territories has been delegated upon the central government. The central government can extend with such modification as it deems necessary through an official notification any particular act which is applicable in any particular state in India to a union territory. Hence, the central government has been vested with the power under delegated legislation, wherein the central government can extend any particular enactment which is in force in a particular state in India to a union territory. Now, a question arises that when a particular enactment is extended to a union territory from a state, and that enactment is declared as unconstitutional with respect to the powers of that particular state legislature, what happens to the power of, what happens to the effect of that particular legislation in a union territory? The answer is that the effect of such a legislation in the union territory is unfettered, provided that the Parliament had power to legislate with respect to that subject. Hence, it is the Parliament which has been given the responsibility and the duty of ensuring that laws need to be formulated for the proper governance of these union territories.